Welcome to the Estates Made Simple podcast with Jenna Carvalho and VanderLeek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to Estates Made Simple. My name is VanderLeek and one of the co-hosts of this lovely podcast, and a pleasure today to have another session with Jenna Carvalho. Welcome to the podcast.
Hello.
Today, we're going to be talking about gifting while somebody is alive. So it's with a view to estate administration, but in the context of a power of attorney. So on the assumption that a power of attorney is activated, the question would be, what can an attorney do? So when we say attorney, this is not a lawyer. Sometimes people say, oh, that sounds like something they saw from a U.S. cable network. An attorney in the States is a lawyer, but when we say attorney, under the Canadian context, somebody acting under a power of attorney. Let's frame that conversation and think a little bit about how does this impact estate administration and how do they interplay? So somebody is still alive, but they've lost their capacity. We have an activated power of attorney. And usually it's drafted. The legislation does allow broad powers for being able to do anything the person would have been able to do to make those kind of financial decisions. The power of attorney is limited to property decisions. And there's some exceptions to that. They're got to be careful about benefiting others unless permitted under the power of attorney. And also certainly you want to be mindful of what the distribution in the estate is and not frustrate the donor's testamentary intent, the donor being the person who made the power of attorney, right? So if you're acting under a power of attorney, you have to be mindful of what is the estate going to look like and what is the distribution. There might be some specific circumstances that how the will is drafted or who are the beneficiaries of the estate is going to influence or impact or have a consideration in the decisions you're making under the power of attorney. So when you're managing that power of attorney, it can include obviously personal property, household items. What do we do with that? There might be a home. Typically people would own property. They would have various investments. But I think we were talking as we're preparing for this session, Jenna, right? We both have seen examples and situations where in fact, some decisions have to be made about dealing with and or disposing of and or gifting some of those assets that you're managing under a power of attorney, and how does that interplay with a future estate, assuming at some point in the future, this person whose assets you're managing would pass away, and how do you protect yourself in this situation? The scenario, we see it frequently, that if somebody becomes incapacitated, they could live for a long time. Sometimes the incapacity is short-lived because the trauma that may have caused the incapacity may very well have other medical issues that shortens one's life expectancy, but of course, not always. The listeners will all think of scenarios that you say, maybe there was an aging parent that lost capacity due to dementia, but was able with supports to live for many years and otherwise be quite healthy. We could have a long-term management of property and circumstances in which you can think about the gifting of property or the sale of property.
And I think there's a couple of areas where individuals may get into a little bit of trouble here. If you're acting under an enduring power of attorney, I've found that when we are opening accounts on behalf of the donor or even transferring an account, let's say from an RSP status to a RIF status, it's really important not to designate any beneficiaries on those accounts that are different than what the donor had made originally. That goes back to your comment about not changing the ultimate distribution of the estate. That's one common area that we need to be careful of. The other deals with what does the attorney do while the individual is incapacitated and may not need those items through life. I think the first step is to consider the individual need the proceeds of such items to live day to day. Do they have enough money to pay for their home care, pay for their any other needs that they may have during life? Or do they have sufficient assets that those personal items or other items can be disposed of? And if they don't need those items, then we look to the will to see if those items are designated to specific beneficiaries. because the attorney has a duty to ensure that if the individual does not need those items, to either preserve them for the ultimate beneficiaries of the estate or perhaps consider gifting them during life. And that's a really tricky decision. Lots of variables go into that. There's lots of risk associated too, and you may need to seek legal advice and perhaps go to the court for direction. But it's a situation that attorneys get into often. Consider if we're going to be gifting items during life. I've personally dealt with a scenario where an individual lost capacity and she moved out of her home, and all of these personal items in her home were supposed to be divided between her 3 children when she passed away. And so we made a decision to actually go to the children during her life and allow them to divide the items, worked with them to make sure it was equal. And then they signed, obviously, a receipt of personal items form so that we ensured that in the end, in the estate, that was all addressed during life.
Which makes a lot of sense. And that, just to provide some comment on that, otherwise would not be in the person's best interest to keep the home there and continue to maintain, insure, and otherwise preserve those personal assets. Maybe the house has to be sold. It has to be cleaned out so it could be sold. Or there's a cost to maintaining that. It could be years and years, which is depleting the person's estate and reducing costs. So I think that's a prudent action to try to minimize costs in that situation. And ultimately, it's going to the right place. It's going where she intended. And clearly, it depends on the facts of the case. But how you position that would be, hey, she's not going to need these anymore. If she's in a care facility and all this stuff's in the house, she has enough personal items, maybe that are nice to have in her home, but she doesn't need all of it. And let's get it to the ultimate beneficiary. And that would save costs in the estate, right? In terms of caring for that or minimizing the risk of loss. What if the house gets broken into and the items are lost? So I think that's certainly a prudent move in those circumstances.
And so a question for you, Gordon, what other variables come into play when an attorney has to decide whether to gift now or wait till the individual passes away?
Yeah, so I think ultimately you want to look at your fiduciary obligations and making sure you meet those. But in the example we gave, you could say that is not impacting her. It's the personal items, right? They're items which may not be of great value, and you're actually improving her financial situation in that example by virtue of disposing of them and honoring her testamentary wishes. So I think, number one, as you've indicated, you have to look at ultimately what the will says. But that doesn't translate into then there's no decisions to be made, right? And in some cases, if we change the facts a little bit, it could be that, for example, the will talks about certain property going to certain children. First and foremost, that property may need to be sold to pay for the ongoing care. There were certainly some situations recently that we were involved with where we had to go to court to get direction, because we wanted to avoid any contention and have a court order that authorized sale. Otherwise, we're going to have a fight in the estate to say, how come you sold that? We had to lead evidence to be able to say the person needs it or they're going to run out of money in their lifetime unless we do sell it. And that would override any wishes in the will, because that's probably what the person would decide anyway. If they had full capacity, right? They might have to just obviously make sure they look after themselves. So you want to look at the specific assets. You want to certainly look at your fiduciary responsibility, what's in the best interest of the person who's incapacitated, and make appropriate decisions. So in the example of the personal belongings, you would say, okay, there's no harm in that, but ultimately you've got to do what's in the best interest and make those decisions. And if you go, there's a bunch of risk, would it be best to put the evidence before the court and get authorization of the court? If you're saying, then everybody has notice of that application, could put their position forward. And if the court listens to that and makes a decision, then there's reliance on that. Can't come back and say, hey, you made a poor judgment and sue the attorney under the power of attorney for making an inappropriate decision. So I think you also have to look at what's the nature and extent of the disability, because you could very well have it. What if the person comes out of it versus they're not going to come out of it? We've certainly seen situations if somebody's in a coma. What if they come out of the coma and they might change their will, right? So you got to be a little bit careful of saying, is this going to be the person's last will? In that context, is maybe they recover and come out of it, and then that's going to affect your decision-making. So you have to take a look at the context to make the appropriate decision. And I think The other action would be appropriate documentation if you are going to do it. The consent of beneficiaries who might be affected, right? That would provide some comfort of knowing that no one's opposing what you're doing and you could document that, or that they actually are acknowledging receipt of a gift based on what ultimately is going to be the disposition in the estate. So making a judgment of future needs would be another criteria. Having some projection, which might involve sitting down with a financial advisor to say, what do we project going forward? That may be intuitive, but at least getting the appropriate advice under a power of attorney to say, what are future cash flow needs, and looking at what the rate of return is that you're getting on current assets. And is there flexibility in terms of distributing that asset? And the analysis obviously is going to be dependent upon the facts of each case. You could have a situation where you have somebody who has $100 million estate versus a $100,000 estate. Two completely different scenarios, and your decision making would be different under those, right? So it isn't here's a rule you could just randomly apply it. It's really judging what's appropriate in the circumstance and ultimately judging what's in the best interest of the person whose money you're managing, right? And the law places a very high responsibility. We've talked about that in other podcasts on the person who's in that fiduciary position. And in that context, you want to make sure that you're not opening yourself up for more litigation and get appropriate advice on the options and how best to protect yourself.
And I think too, it depends on the nature of the gift as well. So if you have
Yes.
personal items that are likely not worth very much, I think the decision is a little easier. But when you have maybe a rare painting or you have a home that's supposed to go to an individual, if you distribute that home to that one child, for example, and the other children don't get anything until mom ultimately passes away, how does that affect? And as you mentioned, does that cause conflict? And how will the estate be managed in that case? So definitely the gift itself is an important consideration.
I think what you're touching on is an important part of the analysis. Is it an appreciating asset? Is it a depreciating asset? If somebody has a car, you might say, what if they're incapacitated for 5 years? That car is going to be worth less. And if you sold it now, and does the person need it? What are storage costs? Are those recoverable expenses? Is that prudent in the circumstances versus if I hold on to this, like a hot market in real estate, maybe it's good to hold on to it. I think the market could decline and there could be a significant loss if I don't liquidate it. Appreciating versus depreciating, in my experience, is certainly one of the factors you're going to look at in making a decision. And also, I guess it goes without saying, read the terms of the power of attorney. It may provide some direction on some of these things in terms of what you can and cannot do as part of your authority under a power of attorney. But I think the theme here is you want to be mindful of what the estate looked like. And that also touches on the point of you got to investigate to make sure there in fact is a will, right? As one of the things you have to look at, is the person going to die pursuant to intestacy rules, or is there a last will? Could it change? What's the nature and extent of the disability? All a variety of factors to look at in making a decision.
And all this to say, you should seek expert advice and go see Gordon and his team just to make sure you're doing everything you need to do. So thank you everyone for listening today. We really enjoyed the conversation. We look forward to talking with you next time. And please feel free to subscribe wherever you listen to podcasts and check out our beautiful faces on YouTube. Thank you very much.
Take care.